Hello, thanks for viewing this video. For anyone who doesn't know, my name is Greg Nussbickel, estate planning attorney, and today's video is going to be a quick and dirty overview of your living trust and the documents that go along with that. Trying to cut through some of the legalese and all the jargon that's in there and demystify some of the documents. By this point, you probably already got a rough draft with your specific wishes and your plan laid out. This is obviously just a general overview, so I'm going to hit the highlights. Some of your particular provisions may not apply. There may be different documents, but in general, hopefully we'll give you a better kind of feel for what all these documents do and the things you should be looking out for while you're reviewing it. So without further ado, jumping right into it, the trust, the revocable living trust in this case, is really going to be the centerpiece of the plan. That's where the distribution wishes, when we're dealing with inheritance, come into play. A lot of the incapacity planning is in here as well. So if you can't handle your own affairs, you're determining who's going to do that and under what circumstances. And along the way, there's just going to be a lot of contingency plans and special circumstances that the trustee is made aware of, and they get their marching orders. And that's really the point of all of this, is to have a more responsible distribution, either for you while you're alive or for your beneficiaries after you're gone. This may be a trust for an individual, or it might be a joint trust for a married couple. The one we have here is individual, just a little easier to go through, but a lot of the provisions are going to match up. And remember, with the trust, there's really three major benefits that you're getting versus just utilizing a will. One is the trust allows you to avoid probate for assets that you actually fund into the trust, that we'll talk about as well. You're also able to protect the distributions that you're making to these beneficiaries when the time comes. So if, let's say, a son or a daughter is in financial trouble, or they have a special need or a disability, or just got sued, or maybe we have a beneficiary who's too young, like a grandchild, you've accounted for all of that, and the dollar that's in the trust is going to be safe from all those other claims and creditors. You're also able to handle your own incapacity planning in a more meaningful way than just, let's say, the power of attorney, which will be part of this as well. But the trustee is really like a guardian that takes over in case you ever need it, and you can avoid that court-appointed guardian if that ever comes up. So the name of the trust right up top here, usually the last name, can be just about anything, but usually keeping it your name is going to make it easier for people to recognize and have less trouble down the road. And then we have the settlor, that's the creator of the trust, and then the trustee. They're usually one and the same, so the person who sets up the trust would also be the trustee. If it's a married couple, usually both spouses would be trustees simultaneously, and then the survivor of them, the one who's alive and competent, would still be running the show in that scenario. And as we scroll down, we have some information about the family situation, marriage, children, and then the successor trustees that you'd like to step in if you can't. So if nobody named above is available or willing, you've got 1, 2, maybe 3 backup people who are going to step in and do that for you. They can work in tandem as co-trustees, or they can be in order, and there's different ways to chop that up. But you do want to name someone you trust implicitly, you know you can count on to do the job. And of course, this trust being revocable means it can be amended at any point, changed, or just done away with if you ever feel like it. So you have a lot of flexibility built in as well. So scrolling down, there's a number of definitions that we won't go into too much detail, but probably a couple worth noting. Number 8 here, for instance, the term issue refers to descendants, so children, grandchildren. It's a shorthand term that we use rather than sometimes naming all of them or describing all of that. And along with that, you see in number 10 here, the term per stirpes is often utilized. And that means if we have a predeceasing beneficiary, their share goes to their children instead. So if I have a child and she dies before me, but she had children of her own, my grandchild, that's who would receive in a per stirpes distribution versus per capita, which would mean however many of the individuals I've named are alive at the time will split equally. So you'll want to look out for that in the distribution section in section 6, but it's defined and described here as well. So obviously a Florida trust here in 2F, it's under Florida law. And 2G is what we call a spendthrift clause. So it's one of the places where we add that protection that I was mentioning. So if you're gone and your beneficiaries have inherited your estate and somebody has a judgment or they just declared bankruptcy or they're trying to get public benefits, the dollar in there in the trust isn't going to get lost to all of that. It won't get leaned or garnished or taken away. So that can be a big help. Special distributions. We definitely want to put in a minimum age to where a beneficiary wouldn't be entitled to everything all at once if they're too young. So 18 would kind of be a minimum, maybe 21, maybe 25. And before that age, if they're entitled to something as a beneficiary, then the trustee would dole it out in a more responsible way. So their health, education, maintenance, and support would be taken care of, but not just anything they have in mind. So it gives a way to protect and control that somewhat for the less mature individuals out there. Let's see, we got an arbitration clause, not usually going to come into play. 2L is just saying if when the time comes and most of your assets have been dealt out and there's a little bit left over, you're just instructing the trustee to go ahead and distribute that out. Don't belabor the trust administration after you're gone. And Article 3 is about how the trustees take care of business. So you've already named them, and this is their playbook, how they come into being a trustee, how they can be removed, what their compensation might be. We usually say just reasonable because we don't know exactly what's going to be asked of them, but that can be adjusted. Their reporting requirements. So you're the trustee to begin with, but you don't have to report to yourself. You don't have to do any accountings. There's no separate tax ID number or anything like that. But when the settlor is gone, or both settlors are both gone, then it becomes irrevocable, and the new trustee has to report for everything, account for everything, make sure it's all above board, but not something you really have to worry about. The authority of the trustee is quite broad, as you might imagine. They act as your attorney in fact or agent. This does not mean attorney, by the way. It's just a term that's used. So they're carrying out your wishes. They're taking on that fiduciary role for you, but they're going to have access to a lot of things. So you want to make sure that the people you can trust. They can access health information, as you see in 3K here, if that's helpful sometimes. If there's life insurance or health insurance issues, they can deal with that directly. You might at one point make your life insurance payable on death into the trust. So you'll see that in 3L, their ability to handle things like that. Or you might have it paid elsewhere. You don't have to have all of your assets come into the trust by any means. But the ones that do, you want to make sure the trustee can manage appropriately and utilize either for your good or for the good of your beneficiaries. And then Article 4 here is kind of a laundry list of all the powers that the trustee can exercise, which is pretty much everything under the sun having to do with trust assets. So anything owned by the trust after you're gone, they're going to be able to step in and invest and manage and pay out and control. Now, of course, they can delegate to professionals. They don't have to be an expert in everything. There can be an attorney. It's not necessary, but sometimes helpful, accountants for a final tax return, those kinds of things. But pretty much they're able to do whatever's necessary. A lot of this is going to look pretty similar to what we see in the power of attorney later on, but the power of attorney is for property and financial decisions for things you own in your name during your lifetime, and the trustee deals with trust assets. Now, these may be the same people wearing different hats, but they have kind of different duties over different things, so it kind of looks like it repeats a little bit. So all of that aside, there are certain things that only you can do as the creator of your trust. So it is revocable, it is amendable, but only you can do that. Okay, so no one else can change the terms of your trust or mess around with your plan. And as I mentioned, when you're gone, it becomes irrevocable, not to be changed afterwards, so that you know your wishes will be carried out. Some of those wishes are that you enjoy your same standard of living that you become accustomed to. You stay in your home as long as that's feasible for you. So this is also where it goes beyond the power of attorney. There's actual duties and responsibilities and instructions about your care in your trust, whereas that power of attorney is more just a permission slip that says help if you feel like it. And then Article 6, we get into the distribution part, usually one of the most important parts. And right off the bat, we see that during your lifetime, even if you're incapacitated as the settlor, you're going to be the beneficiary. So this is all for your benefit while you're still here. Even if that swallows up every last dollar, that's fine. And then after your death, there might be taxes or enforceable debts that get paid first off the top. So that you'll have to see when the time comes. And once all those are taken care of, really towards the end here is when you're making your decisions about who receives the rest of what you might own. And that might just be anything, real property, personal property, tangible, intangible, anything that you haven't earmarked elsewhere in the real world is going to end up in the trust. It's either going to be owned by the trust at your death, or as we'll see, your will is going to put those things into the trust regardless. So of all of that, you're determining who gets what. And this first paragraph here is usually about personal property. So we're talking the jewelry and the furnishings and the tangible items that you might have, because you might want to give those away differently. And if you do, there's a separate memo that we use for that purpose. And the nice thing about that memo is you don't need the witnesses, you don't need the notary. You can kind of do that on your own at any point. So if is anything like that, that memo would take care of it, and you can change that at will on your own down the road. And there might be some specific bequests in here, devises, so $100 to a particular family member, or a certain percentage to, could be a charity, could be a friend, whatever that might be. So we take those off the top, and then the remainder, the residue of your estate, whatever's left that you haven't given away otherwise, is going to go oftentimes to your descendants, your issue, your children. In this case, just the one child, that's all we had per stirpes. Again, if that child predeceases, her children would get everything instead, subject to that minimum age of 18 that we saw and those other kind of caveats that may come into play. And this is kind of a catch-all. Sometimes we put it in there, if there's nobody left, which is pretty remote, then it would default to your heirs at law, or you can pick some other particular beneficiaries if you'd like. Then there's the signing and the affidavits that go with that. So that's the trust. That's kind of the hardest part there. A lot of times people get a little confused with it, exactly what is a trust, but it's a contract, it's a set of rules that you put into place that are going to apply to the assets that you put into the trust. You more or less ignore it during your lifetime, but that successor trustee is going to have all these good instructions, controls, and protections and all that. So the rest of it, I think, is a little more straightforward. Again, these documents might vary, but you might have an assignment of personal property, or sometimes a declaration of trust that we just use as part of the funding process. So the assets that you have that don't have a title ownership or a deed associated with it or account number, you're saying those are now part of my trust. I sign my trust and those things are now owned by it. So it's just less that would have to go through a probate or go in some other direction. Now the actual assets like bank accounts or brokerage accounts, you want to actually go to that financial institution and make the change there. Oftentimes make that checking account payable on death to your trust, or the brokerage account owned by your trust, and we can guide you in that direction a little bit as well. This is that separate memo if you ever want to fill it out. Usually leave it blank, but a nice convenience for the future if there's some jewelry you'd like to go to your daughter or something like that. And then we have a will. Of course, a will only kicks in after somebody dies, and the only purpose of these wills are to make sure that assets that you owned at death that weren't already in the trust name end up in the trust name. So you say, I sign this trust and I'm deciding who I would like to be the personal representative, which actually handles the probate. And remember, all wills, if they're going to be used, are going to be used in probate. So you're nominating the right person, the executor, and you're saying who those beneficiaries are going to be. And it's just the trust. Okay, we've already done all the planning in the trust, so you just refer back to it. We call this a pour over will. You're pouring assets into the trust that weren't there, so there's no need to repeat this or even to change this. If you change the trust, it still reads the same. And you might not even really be using the will if everything was funded to begin with, but this way you have your bases covered. And so again, we sign these, and you'll see affidavits that go along with some of these documents that are just to prove that everyone was there and signed at the same time and all that kind of thing. The rest of the documents are just for you during your lifetime. So we alluded to the power of attorney earlier being a permission slip. You're saying who's going to step in and pay those bills and sign contracts, all in your best interest, all in good faith, of course, but again, have to be the right people because they're going to have access to funds and they can remove and deposit and all those kinds of things. So choose wisely, but you're giving them broad authority so that when the moment arises, they're going to be able to step in and do that for you, because obviously if you're incapacitated, it's too late to do these, so you want these in place beforehand. It does continue in effect even after you're incapacitated. That's what the durable part is about. But it kicks in immediately. So as soon as you sign this, at least your first choice here is going to be your power of attorney right away, regardless of your capacity, because that's what Florida law requires. They can't be delayed for when you're actually incapacitated or have those springing powers anymore, but they work better because they get honored more often. And so you just want to be mindful of that. And as you go through all of these powers, could be a little bit overwhelming. There's a lot of detail. These used to be a little more straightforward, and now they're a lot more involved than they were. But you're pretty much just saying, whatever I can do over my assets, I'm allowing this person to do for my benefit. So they can withdraw funds, but they can't use them for their own purposes. And of course, you could revoke or amend this document just like anything else if you're ever unhappy with how it was playing out. And similar to that is a designation of healthcare surrogate. So it's similar to power of attorney in that you're appointing an agent, in this case a surrogate, to take actions on your behalf, but they're going to be about talking with your doctor and helping with procedures if there's some kind of medical emergency. A couple things you'll be deciding and maybe writing in when you come in for the signing appointment: organ donation wishes, if you'd like, exactly when this document takes effect. The health surrogate you can actually delay until you're incapacitated, or you can make it immediately effective, like the power of attorney, if you'd like. So that's up to you. And a living will, which you'll notice we're not choosing anyone on here, we're just deciding what circumstances would come into play where you wouldn't want life-prolonging activity to continue. So if you're incapacitated, you can initial 1, 2, or all 3 of these. So whatever you've initialed, you're in that condition, and the doctors feel like there's no hope. You're saying you don't want things prolonged unnecessarily. And then the surrogate carries out those wishes for you, kind of takes the pressure off of them in that circumstance. And then a lot of times you would choose burial or cremation wishes if you've already got a plot, or if there's some preferences that you have on viewing or anything like that. Would kind of wrap things up. Again, there might be some other things or some omitted in here, different provisions, but hopefully that gave you a pretty good idea of what you're looking at there. Of course, we're here for any kind of specific questions, or if anything needs to be changed, just let us know, and appreciate your time.